This week we're going to talk about inchoate offenses. What are they? They are not fully formed or developed crimes, or they're just beginning. They're rudimentary. They can be left unfinished or incomplete. Some examples of those are crimes of attempt, crimes of conspiracy, and crimes of solicitation. These are uncompleted crimes. These actually are crimes. You can be charged with an attempt of, let's say, arson, attempt of robbery. You can be charged with conspiracy, where you are discussing committing a crime with somebody else. And then there's a crime of solicitation, which means you're trying to get somebody, talk them into doing a crime for you. Solicitation. And we're going to be more specific. That's very general discussion of these three. But what they are is they're an incomplete crime. No crime has actually taken place. And they are their own crime in and of themselves. Different from the accessory or the accomplice, which is actually part of a crime in and of together. If you are an accessory or a accomplice, you get charged the same as a person who committed the crime. You don't get charged in a separate class if you're the accomplice. Now, what's the rationale for supporting punishment for an uncompleted crime? Is it fair? There's two reasons. Prevention, right? Let's prevent crimes from happening. And deterrence. What if law enforcement can only make an arrest only after a crime was committed? They could stand by and watch, someone get mugged or a theft occur. They couldn't step in to stop it. What if they couldn't intervene? What if a defendant is unable to actually complete their crime? So they're going to try and try and try again without any consequence? Should people be punished for not actually committing a crime? Is there any problem you see so far with charging people who haven't committed a crime? If we can charge people for not actually completing their crime, what's the question that raises? Well, how do you know when you get to the point of being able to charge them with one of these, right? How far does the crime have to happen, right? Where is there no, the point of no return? Where do we draw the line for an attempt? Where do we draw the line for what is a conspiracy to commit a crime? Solicitation. So that is the question that we're going to discuss. But I posed to you three examples to consider. Susie, tired of her marriage, decided to kill her husband Bob. And she's going to collect the life insurance. She purchases a pistol. She took shooting lessons. And she put the gun in the drawer next to her side of the bed. Pretending she heard a burglar late one evening, she induced Bob to go outside and investigate. Susie shoots Bob in the head, and later telling the police she thought he was a burglar. Bob did not die, but lived on in a vegetative state. What was Susie's intent here? What, based on those facts? She wanted to kill Bob for life insurance. Did she? No, she didn't succeed. But does that mean she gets away with whatever happened here, or something else can happen here? That might be her story, by the way, saying, oops, yeah, I thought it was a burglar. But after a police investigation, they see that she bought a gun and took shooting lessons. Can she be charged with murder? No, because he didn't die. Could she be charged with maybe attempting to murder? We'll see when we go through the elements, but it sounds pretty good, doesn't it? What about Susie loaded her pistol, snuck out the back door, and unknown to Bob, with her finger on the trigger, aimed directly, let's say, at his head. I don't know why I have heart there, because we did the head in the last example. Aimed directly at his head. She fired, but the gun only made a loud noise. Unknown to Susie, she had loaded the gun with blanks, thinking they were real. It's certainly not a completed crime, but maybe it's something else. She certainly tried to kill him. Susie loaded her pistol with real bullets, snuck out the back door, and unknown to Bob, finger on the trigger, aimed directly at his head. That should be head again. Suddenly, she's confused, and she's upset, and she stops what she's doing, and she sneaks back inside without being detected, puts her gun away, and she waits for Bob to come back. Do we have a crime here? This one's a little different. The other two, certainly we've given rise to some sort of, she should be. I mean, we haven't gone through the laws yet, but you should be going, God, she should get in trouble for those first two. But this one, maybe not. So let's talk about attempt. Basically, attempt is a crime that's left unfinished. Trying to do the crime, haven't quite got there yet. When does it become punishable? And I'm being very general. We're going to break this down a little bit further. You need two things. The person needed to intend to commit the crime and took significant steps to commit the crime. So in our examples previously, Susie, in the first two, did she intend to commit a crime? Yes, she intended to kill Bob. Did she take significant steps? I would say that she did in the first two examples. The third one is a little sketchy. We'll come back to it though, because we'll see about whether or not she can undo what she's done. But that's the general gist of attempt, and now we're going to expand on it. At common law, attempt wasn't a crime. So if I tried to run you down with my horse and buggy and somebody pulled you out of the way, I couldn't be charged. But over time that has evolved. The common law now does recognize it, but nevertheless all the states actually have a statute that charges one with a crime of attempt. So if I'm at your house and I am a firebug and I find a lighter and I try and light the bottom of your curtains up, but they're anti-flammable, and they start to smoke, but then the flame goes out, and I try and do this several times, and then you come in the room I'm in and you go, hey, what are you doing? Catch me in the act, you call the cops, and I'm arrested. But it's not arson, because I didn't burn the place down. But is it attempted arson? All I wanted to do was light the curtains on fire. And what would happen is probably burn the house down. So attempted arson could be a charge in that case. Now let's talk about these attempt statutes. There are two types of attempt statutes. One is general. Some states, and New York is a general attempt state. What that means is there's a specific statute that sets out the elements for attempt. And then you take those elements and you apply them to the criminal offenses, all of the criminal offenses. So attempted murder, attempted arson, attempted petty larceny, attempted burglary, attempted robbery. You just attach the statute to all of the criminal offenses. And like I said, New York does this. This is what New York's law looks like. It's a specific statute, and it says a person is guilty of attempt to commit a crime when, with intent to commit a crime, he or she engages in conduct which tends to affect the commission of such crime. So you will see this statute attached to a crime statute. Attempted to sell drugs, attempt to commit murder, attempt to assault. That's a common one, attempted assault. But it goes a little bit further. and it gives us the meaning and the definition. Intent. Intent means this is for attempt. You still need intent or a mens rea. Intent means a conscious objective or purpose. Thus, a person acts with intent to commit a crime when his or her conscious objective or purpose is to commit that crime. Conduct, there's another we're going to go through this a little bit more. I'm just giving you plenty of examples. Conduct which tends to affect the commission of a crime means conduct which comes dangerously close or very near the completion of the intended crime. Think about Susie in that last example. Did her conduct tends to affect the commission of a crime? Means conduct which comes dangerously close or very near the completion of the intended crime. What she didn't do was pull the trigger, unbeknownst to anybody else. Think about that one. We're going to revisit it again. So the test here in New York State, if a person intends to commit a crime and engages in conduct which carries his or her purpose forward within dangerous proximity to the completion of the intended crime, he or she is guilty of an attempt to commit that crime. It does not matter that the intended crime was not actually completed. And those 3 slides that I read off to you, that's how a judge would read them off to a jury if they were determining a crime of attempt, whatever the crime happens to be. The next discussion the court will have is what the crime is. The person's conduct must be directed towards the accomplishment of the intended crime. It must go beyond planning and mere preparation, but it need not be the last act necessary to effect the actual commission of the intended crime. Rather, the conduct involved must go far enough that it comes dangerously close or very near to the completion of the intended crime. Think about Susie. She got really, really, really close. We'll come back. We're gonna work through more examples of this test. Right now we're talking about general and specific attempt. So New York is a general attempt state, meaning it has its own law, and I just went through it with you. We'll talk about specific tests that are available. Specifically, we'll go through these, but I wanted to point out here, New York and many states are a general attempt state, which means they have a specific statute for the law of attempt. Now, specific attempt is defined within the bounds of the crime. And just probably best to give you an example. The federal crimes are this way. This is how the federal government and their crimes define attempt. They don't have a special statute for it. It's just named right in the crime. And this is under the U.S. Code for bank robbery. Whoever by force or violence or by intimidation takes or attempts to take from the person or presence of another or obtains or attempts, there's another attempt. So it's written right in the specific statute. So they don't have a statute that they have to cite to. If it's written right in the law itself that this crime will be a crime, even if you attempt to do it, it's right in the actual law. And just to carry it forward, the test that the government uses in order to carry its burden of proof for the crime of attempt, and I've snuck in bank robbery there, crime of attempt to bank robbery as charged, the government must prove the following 2 things. First, that the defendant intended to commit the crime. Second, that the defendant engaged in a purposeful act that under the circumstances, as he or she believed them to be, amounted to a substantial step toward the commission of a crime and strongly corroborated the criminal intent. So here's another test that we will look at and go through. But for the feds, you need a substantial step. Do we think Susie in our last example and the third example, her conduct amounted to a substantial step? Did she take substantial steps? Let's finish it out. A substantial step is an act in furtherance of the criminal scheme. A substantial step must be something more than a mere preparation, but less than the last act necessary before the substantive crime is completed. The substantial step may itself prove the intent to commit the crime, but only if unequivocally demonstrates such intent. So, our substantial step has a definition. It's an act in furtherance of a criminal scheme. A substantial step must be something more than mere preparation. Okay, does this help Susie? She prepared for what she was going to do to Bob, but stood in the yard or wherever they were, and she had her gun to his head and then stopped. Does the first part of that just constitute mere preparation? Or the fact that she got out of bed and claimed there was a burglar and snuck down and just has the gun to his head? Or are we going to forgive her and say, no, that's not it? Maybe she won't change her mind the second time? Something to think about as we move forward. So, as we discussed, all crimes require a criminal act, right? We need a criminal act, we need a mens rea, or actus reus and a mens rea. So what's the criminal act in an attempt case? Well, it's going to depend on which jurisdiction. So let's work through some of these things. Thoughts. What if you're plotting and planning? What if you're thinking about killing your spouse? What about you make plans and you plot, maybe you write about it in your diary. You prepare, like Susie did. Take shooting lessons and you buy a gun and you actually make some preparations. Well, these things, thinking about it, planning or plotting it, preparing for it, we have to buy some other things that go along with the crime you're going to commit, mask if you're going to commit a robbery. These things aren't enough. So what does? What is enough? The crux is to ask, how close does the defendant get to completing the offense? Right? How close to completing the offense the defendant must get to fulfill the attempt criminal act requirement? How close? And it's loosely defined jurisdiction to jurisdiction. So it gives a jury or the trier of fact flexibility to separate true criminal attempt from non-criminal preparations. Okay? And there are 4 different tests. I kind of gave you a little snapshot of 2 with the New York law and the federal law. And that's the federal law in New York State, by the way. It's the federal law, but I took it from a New York case. I'm sure that's the same throughout the country. The judges may amend their wording slightly when talking to a jury, so I wanted to make it, those came from New York cases. So let's talk about our 4 tests. We have 4 tests. Initially, I told you way back in the common law, early common law, there was no such thing as attempt. And it evolved over time. It evolved basically under common law to this. Some states, few states, still use this last act test. And what that is the defendant must take the last step within their power to commit the offense. I think this one's the most favorable to a defendant to say, I didn't commit attempt of that crime, because you have to consider what the last step would be. Let's talk about Susie. Where do you think the last act would be? point of no return when she shoots the gun. If we were under the common law test in that last scene for Susie, she would not be found guilty of attempt, because the last step would have been her pulling the trigger. What would have to happen in the last act step? You pull the trigger and miss. That would be a solid attempt under the last act test. Why? In that example, because she has time to repeat it. Oops, I missed the first time. Let me do it a second. Let me try a second time. She has an opportunity to repeat it. So this one is the most favorable to defendants. The next one we have is why don't I have my, I think I skipped one. Well, let's do this one. No, I didn't. No, we're good. The res ipsa loquitur test. The thing speaks for itself. And this test measures the trier of fact must determine that at the moment the defendant stopped progressing toward completion of the offense, it was clear that the defendant had no other purpose than the commission of the offense. This is basically decided on the defendant's acts. Based on defendant's acts, it's clear that the defendant had no other purpose than to commit this crime. So that's what the trier of fact has to determine. I think I have an example. I do. Harry wants to kill his wife Ethel for life insurance money. Harry contacts his friend Joe, who is a hitman, and sets up a meeting for the next day. Harry meets Joe and asks him if he will kill Ethel for $1,000. Joe agrees, and Harry gives him a wad of cash and pays him. But Joe is a law enforcement decoy, and Harry is arrested. So the question is this attempted murder? Is there any going back? Is there any other purpose? Would there be any other purpose here? The answer is no. This would be an attempt under the res ipsa loquitur test. It speaks for itself. Say the thing speaks for itself. He wants to kill his wife. He contacts Joe, who's the hitman. They have a meeting. Joe agrees, and he pays him in cash. Like, there's no going back. Sure, maybe the next day he can call up Joe and say, I changed my mind, give him my money back, but it may be too late. So you decide. There's some wiggle room for some further discussion in that, but remember, we're talking about the res ipsa loquitur test. The thing speaks for itself. What does it speak to you? You're the jury. How about Joe? Joe lights a cigarette with a match and then drops the match in a haystack in a barn and leaves. Fortunately, the hay burns, but not enough to ignite and burn the barn down. Joe is arrested for attempted arson. We're still working under the res ipsa loquitur test. Thing speaks for itself. The question you have to ask, would there be any other purpose? Based on defendant's act, it's clear that defendant had no other purpose than to commit a crime. Do we have any thoughts here? Joe lights a cigarette. There's another purpose. He's lighting up his cigarette. And he drops them. He's careless. Does this sound more like carelessness than an attempt to burn down the barn? Probably. I just make sure you ask yourself when we're talking about that kind of test, res ipsa loquitur, would there be any other purpose? And yeah, in this case, there's another purpose. Our next test is the proximity test. And this is the test from New York. This is in that statute that I read to you. We're going to revisit it. And it measures the progress, the defendant's progress, by examining how close the defendant is to actually completing the offense. So if we are in a jurisdiction with the proximity test, you're going to ask yourself, how close did the defendant come to completing the offense? You're going to ask, what is left to be done here? Don't look at what has been done. The preparations, the plotting, the planning, the thoughts, none of that matters. What is left to be done? You're going to measure the distance between preparation for the offense and successful termination to the crime. Okay? That's what we're going to use here when we go through our next examples. I'm going to give you law here. So this is what we read a little earlier. If a person intends to commit a crime and engages in conduct which carries his or her purpose forward within dangerous proximity to the completion of the intended crime, he or she is guilty of attempt to commit that crime. Does not matter that the intended crime was not actually completed. Okay, so this is going to be our test, and let's run through some examples. At lunch in a bar, Joe, an undercover cop, inquired if Sam could sell him some cocaine. Sam said he would call his suppliers, which he did. Sam then told Joe that he would have a pound of cocaine to sell him at the same bar at 6 p.m. that evening. He told Joe to return alone and with cash. Joe agreed and left the bar. While picking up the cocaine from his supplier, Sam was told of a rumor that the FBI was in town working undercover trying to set up drug buys. Sam gave the cocaine back to his supplier and did not go back to the bar that evening. Sam's arrested 3 days later, charged with attempt sale of drugs. What do you think of this one? We're using the proximity test. The question, what's defendant's progress? What is left to be done? Got to measure the distance between preparation of the offense and the successful termination. We have Sam going to his supplier and getting some drugs, which he could have gotten, but he said, nope, I'm giving them back to you. I think the charge of attempt here is improper, and hopefully you reach the same conclusion, because there's a lot left that has to be done. Like, he literally has to return. He has to get money from the agent and then give the agent. There's still a lot that has to happen here, and all that happened was preparation, mere preparation. So under this test, the attempt will fail. Sam, same example, but Sam blows off the rumor as just that, a rumor. Returns to the bar at 6 p.m. and provides the pound of cocaine to Joe, and he takes the cash. As Sam leaves the bar, he is arrested by the SWAT team waiting outside. Unbeknownst to Sam, his supplier, who didn't want to get snitched on by Sam in the event that Sam got caught, gave Sam a pound of flour. When the contents of the baggie was tested, it tested negative for illegal substance. It actually didn't test for illegal substance, okay? When the contents of the baggie was tested, it did not test negative. It tested negative for illegal substances. It didn't test positive. Long day here. Okay. So basically it's flour, didn't test for drugs, and now he's charged with attempted sale of drugs. Does this stand under the proximity test? We're going to measure the defendant's progress here. Did he get close? Oh yeah, he did it. He actually did it. The fact that the substance is flour, Sam understood those to be cocaine. So he could be charged here with the attempt. He went actually the whole distance. There's nothing left to be done. He did it. So in this instance, under the proximity test, Sam would probably be found guilty of attempted sale of drugs. The probable distance test. This is where we're going to focus on what did the defendant do? How far did he or she progress? So this is kind of the opposite of the proximate test, okay? We're going to focus on what the defendant did versus what is left to be done. How far did the defendant get or progress toward the crime. The question is, did the defendant cross a point of no return? When the defendant has crossed the line beyond which it is probable he or she won't desist unless interrupted by an outside source. Okay? And those outside forces might be law enforcement or other circumstances out of their control. So you're going to ask, did the defendant cross a point of no return? Such as you're in the store, it's open to customers, and you go to use the restroom, and as you have to go to the restroom, you walk by the office area of the store, and the door is cracked, and you kind of, oh, well, let me see what's going on here, and you go in, and oh, look, there's a safe over there, and you go and you check it to see if it's locked, and it's not, and you open it, and there's a wad of cash, and at that moment, the police walk in. Let's just say there was a police officer there getting coffee. They walk in because they were going to use the restroom, and they see you in there. They were following you. What do you think? Just seeing it sitting there in the safe? Is that attempt? What if you're just looking around? I'm just looking around. I just want to see what's in this room. You may not have intended to go. Did you intend to go in there? And there's a reason why you went in the office and then saw an open safe. You might have not been planning on going in the office. But there's a good possibility that can get you an attempt charge. You'd have to argue the next topic we're going to talk about, which is the mens rea. But let's talk about this next example. A terrorist checks a bag armed with a sophisticated explosive device designed to explode when the airplane reaches 300,000 feet. Okay, the bag is checked. The individual's on the plane. Let's say it never goes off. It fails. Did the defendant cross a point of no return? Then it's found. It's detected by law enforcement in the baggage claim when they land at the other destination it was headed. Point of no return. An attempt. Some terrorist act will say attempt of some terrorist crime. I would say so. That would be an attempt. What if the plane never gets off the ground? Oops, we can't go anywhere. It's, we're having a mechanical issue. Still, the defendant crossed the point of no return here. How does he stop it? It's already checked through. So that is an example of the probable dissidence test. And I believe this is our final test. The substantial steps test, and this is the model penal code, and this is the one that the federal government uses, which is the one I cited at the beginning. There is a two-part test. It's, as it is on the screen there, an act or omission constituting a substantial step in the course of conduct planned or culminated in the commission of the crime. Number one. And you need both of these, and the actions must corroborate the actor's criminal purpose. I have a little note there that the book lists, there's a number of things that the statute actually says what consists of substantial steps. So if any of these things exist, then you kind of have number one met, okay? Just to buzz through them. Lying in wait. Enticing the victim to go to the scene of a crime. Investigating the potential scene of the crime, unlawfully entering a structure or vehicle where the crime is to be committed, possessing materials that are specially designed for unlawful use, possessing, collecting, or fabricating materials to be used in the crime's commission, and soliciting an innocent agent, to commit the crime. So all of those things constitute number one, okay? An act which constitutes a substantial step in the course of the conduct planned. But you also need number two, right? That the actions must corroborate the actor's criminal purpose. So that doesn't mean that there aren't other things that constitute a substantial step. These are just the specific things, if they exist, will constitute a substantial step. So let's go through some examples here. Last week, Terry, a college student about to graduate, told Dennis that he is going to hack into Sally Mae's computer system and erase all of his own student loan records so he would not have to pay his humongous debt. That same day, he researched on the internet hacking techniques, which included how to penetrate computer security systems and erase files. He downloaded this information to his computer. Is this an attempt? Is this taking substantial steps? Might be. You might get some steps here moving forward. I mean, certainly he's not. Let's see if he covers any of those things on the list. He's collecting information. He's got he learned some techniques to include how to penetrate the computer system. So he's educating himself. He told his friend about it. He downloaded the information to his computer. I don't know if we're there yet for substantial steps, but let's say he has. Has he met number 2? Actions must strongly corroborate his criminal purpose. He just might be, maybe we're going to write a paper on how to hack the system. I don't know if we're there yet on attempt for this example. How about this example? Continue. Yesterday, Terry wrote a program that would penetrate Sally Mae's internet site security system and obtain the remote access telephone number that would provide him entry into the site. And now he's caught. What do you think about this one? We're getting closer. Certainly we're getting closer. And if he's arrested at this point, it's possible. Anything is possible. We got substantial steps, but do we have does it go towards his criminal purpose? Does it corroborate the criminal purpose? It does. It's certainly getting closer. If not, I'd say I'd say we're there. I think this would be a question for a jury, whether that would be enough. These are the things that they consider. When we talk about these things, there may or may not be an exact answer, because you have to think of yourself as the trier of facts. So you got to look into these things and ask yourself those questions that I'm posing. So earlier today, Terry loaded the hacking program he had written into his computer and dialed the remote access number for Sally Mae's internet site. He was met with an unexpected firewall. The system denied Terry access to his files because he was not using a pre-designated computer to access the site. The system posted unauthorized attempt to access system. Please contact the administrator and listed an 800 number. And Terry quickly exited the system. What do you think about this one? I think we're there. This is definitely attempt. The one in the middle was like, ooh, it can kind of go either way. The first one was probably still early. But this one is definitely an attempt under the substantial steps test. All right, before we do this example, I just want you to think about, those are the 4 tests. I want you to think about the tests. Is one more lenient than the other? Which is more likely to lead to conviction? Which one is more likely to lead to acquittal? I think I alluded to that throughout the discussion, but I want to make sure you've picked up on those and have that information. So let's talk about Max. Max wants to collect fire insurance on an old tenant's building that he owns, which contains 25 apartments. Late one evening, he spilled gasoline in the basement and set a time-delayed fuse, which erupted into flames at 3 a.m. By some miracle, most of the tenants escaped the resulting fire without serious harm. However, 2 tenants were horribly burned and almost died. He is charged with attempted murder. Do we have an attempt crime? Do we have attempted murder here? Now you got to Remember, we were just talking about attempt and the various tests, and we were putting the tests together, but we didn't tie it into the crime yet. We weren't talking about the actual crime. In this case, attempted murder. And if you remember, with attempt, the attempt has to be related to the crime he is charged with. That's the point, right? So here, he wants to collect fire insurance. That's his intent. He wants to collect fire insurance on the building. So he's going to burn the building down. But what wasn't his intent? To kill people. Like, he wasn't intending murder. Arson, clearly he can be charged with arson altogether if he is caught, but attempted murder. People died. He said, well, I didn't intend to kill those people, so I shouldn't be charged with anything. Our next topic, Chapter 9, next week, we're going to talk about the various homicides. But the purpose of this example is to roll us into the next topic here, which is the mens rea portion of attempt. So just to play this all the way out, he would not be able to be charged with attempted murder because that was not the intent. However, that does not mean he's going to get away. Get away with it. He might be something less than that, like manslaughter, and we'll talk about the difference between the two. But it won't be murder is an intentional crime. You have to intend to do it, intend to kill someone. So here, not attempted murder, probably charged with arson and maybe some other lower level homicide offense. But the point of this is rolling us into the mens rea for attempt, the specific attempt. The specific intent you need is intended. It's a specific intent crime, so you need intended or purposely. Why? If you're going to see an attempt crime, you need a specific intent or purposely to commit the crime at issue. Because with attempt crimes, it's like hard. How do you commit a crime recklessly? Recklessly, you either intend to do the crime or you don't intend to do the crime for an attempt charge. You have to actually have intent or purposefully. There's no recklessly, or negligently. Does that make sense? How can if Susie is arrested for attempted murder of her husband, Bob, they have to show that she intended murder. In the last example, the proof is you have to prove that our fellow there attempted murder, and what he was doing was arson. Recklessly, think of recklessly. I know we haven't tied any of these into specific laws yet, but recklessly is a complete disregard. You actually have to do, you're arrested because of your conduct being in disregard or depraved heart. So it's a little hard to have that in an attempt crime. You can't. So if there's a couple of examples further in this book regarding a statute for arson. I, for some reason, don't have it on my slides here, but take a peek at that example in the book that kind of flushes out recklessness relative to attempt and how it does not work. I think it makes sense if the point of attempt is you're trying to stop the crime that someone is actually intending on doing. If you think of it in that sense, you have no idea if you're going to commit a crime if you're doing something recklessly, like driving around in a parking lot. You got in a truck and your friend is hanging off the back because it's a lot of fun to ride in the back of the truck, and you swerve around and they go flying out and they hit a telephone pole and they die. Well, you didn't intend to kill your friend, but you were acting recklessly, and you're certainly going to get charged with some sort of reckless version of probably manslaughter, or in some sense recklessly level of murder. But you can't get charged with an attempt, or let's say they hit their head and they end up in the hospital and they're seriously injured or brain dead. You didn't intend the conduct. It was reckless behavior, but it doesn't mean there's not a charge for it. But you can't get an attempt. Oh, attempted murder. Well, I didn't intend to kill him. I didn't intend to assault him. You didn't have the intent to do that act. Does that make sense? I hope so. If not, shoot me an email and I'll find some more examples that I could post. Can you have a defense to attempt despite your preparations? Can you have a defense? There's actually two defenses that you can have. There's one, despite your preparations, your crime was impossible to commit. Or, on the other hand, despite your preparations, you stopped, you abandoned the plan. The question is, how far have you gotten? So we have two defenses we can use here. It sounds very much like mistake of fact and mistake of law. It's called impossibility. Factual is based on the facts. The facts are as the defendant believes them to be, and legal is the law is not as defendant believes them to be. And abandonment, and we'll go through these in more detail. And abandonment stops progressing. That's what a defendant does. They stop progressing towards their criminal purpose. Maybe they have a change of heart. Okay. An individual smuggles a prescription drug into the country, thinking it is against the law, but there's no law forbidding the importation of that particular drug. Right? That's a legal impossibility. Trying to see if I got another one. Yeah, I got a couple of them. Let's do them. Factual impossibility is rarely a defense to attempt. We've actually kind of talked about this when we talked about mistake of law. It runs the same way. Sam blows off that rumor as just a rumor, returns to the bar at 6 p.m. and provides the pound of cocaine to Joe and takes the cash. As Sam leaves the bar, he's arrested by the SWAT team. And unbeknownst to Sam, his supplier, who didn't want to be snitched on, gave Sam a pound of flour. When the contents are tested, they do not test positive for illegal substances, and Sam is now charged with attempted sale of drugs. Can he argue impossibility? Well, it's impossible to charge me with attempt because it was cocaine. Or it was flour, not cocaine. Yeah, not in this instance. Because that's a factual issue. He can totally be charged with attempted sale of drugs here. And he understood it to be, right? The facts are as he believes them to be. And what did he believe them to be? He believed it to be cocaine. How about a pickpocket tries to pick someone's pocket, but there's nothing in there? And then they're arrested because a cop sees it happen. Well, there wasn't anything there. Nope. That is still an attempt to theft. A hunter shoots at a stuffed deer out at hunting season. He thought it was real. He's still shooting at a deer out of season. Just happened to be a stuffed deer. Factual impossibility. No defense. There's no defense. Legal impossibility. A person who engages in behavior he or she thinks is a crime, but it's not. This is the example that I gave right out of the gate at the beginning. You're smuggling. Let's see, do I have? Yep, here. Let me give you an example. Even if you think you're breaking the law and there is no law, there's no crime, right? That makes sense. So Quentin loves his Cuban cigars. He thinks their importation into the United States should not be a crime. He purchased several high-priced cigars and hid them in a secret compartment in his suitcase. A customs inspector discovered the cigars at the airport. The cigars are Cuban, but there is no criminal law forbidding their importation. Can he be charged? No, he can't be charged. How about the other defense? Oh, before we get to the other defense, I just kind of want to do a recap of that impossibility. factual and legal. You want to it's a little tricky. You want to focus on what the defendant thought he was doing rather than on what it turns out he actually did. If you focus on that, I think you'll be able to distinguish between the two. If there is no law making what the defendant intended to accomplish a crime, then it's a case of legal impossibility, okay? If there's actually no law. Otherwise, most cases are going to involve factual impossibility, which is not a defense to attempt. Therefore, the only question is whether the defendant's conduct satisfies the actus reus requirement of intent, of attempt. Did he intend to do it? Okay? Intend to do the underlying crime. All right, one more defense, abandonment. I was alluding to that throughout the discussion. It's an affirmative defense that the defendant must prove by a preponderance of the evidence. It did not exist under common law. Majority of the jurisdictions allow for it. It's also called renunciation. It's the other word. That's what the Model Penal Code calls it. Why is this a defense? Why would we give somebody a break? Let them think about what they're doing, right? It gives one the incentive. It's actually what it is. It gives someone an incentive to stop progressing toward the commission of offense and prevents the crime from actually happening without having to get law enforcement intervention. Basically, you come to your senses, okay? You abandon it altogether. Not postpone it. That doesn't count. Oh, I'm not going to do it right now, but I'll do it later. That's not abandonment. You have to stop it altogether, okay? You need two things. It's a two-part test to establish abandonment. Voluntary. Has to be voluntary. It's not motivated by detection or that it got hard to commit to. Overall, it's voluntary. You get a change of heart. And you have to completely do it, not postpone. So let me give you the actual law. That is my condensed version on the screen. So in the book, you'll probably see it fully drawn out, but the defendant abandons his plan offense voluntarily, and doing so is not motivated by increased possibility of detection or a change in circumstances that make the crime difficult to commit, okay? You need remorsefulness, you need a change of heart, and the abandonment is complete, and not postponed. This can be an uncommon defense. I'm trying to think of a time that I have used it or seen it, but I don't think I have. Can you be charged with attempt to commit a crime and the actual crime? Oh, actually, wait, I just want to go back and finish up Mary. Not Mary, Susie. Told you I'd come back to Susie. That third example with Susie from the beginning. Did she abandon? Was it voluntary? Was she motivated by remorsefulness, change of heart? I think it sounded like it from the facts. Completely. Well, I didn't give you any facts that said, well, she was going to do it next week, or didn't feel like it was a good time to do it. She went back to bed and was waiting for Bob, right? So Susie might have a defense of abandonment. Can you be charged with attempt to commit a crime and the crime itself? No. Well, that would not make any sense, right? If you committed the crime, you'd just be charged with the crime. So no. The attempt ultimately merges into the actual crime once the crime is completed. And what do we have? One more example. Noreen needed money for a down payment on a new home. She decided to collect insurance money on her wedding ring worth $8,000 against theft. She drove to a distant city and sold it to a jeweler. 2 days later, she broke a window and ransacked her bedroom where she kept the ring. She then called the insurance company and asked what steps she needed to do to be paid for the theft. The company said they would pay her if she filled out a police report and then submit the claim. Noreen reported to the police that her ring was stolen. 3 days later, overwhelmed by guilt, she confessed to the police. Is this abandonment? I'm not too sure. That's abandonment. What do you think? She still did all of the steps that got her where, I mean, there was no other place to go. The insurance company said, well, you have to fill out a police report and then submit it. She did. She reported to the police that her ring was stolen. The steps were all done. She committed fraud. This is fraud. Or some sort of theft. But I think it's fraud. 3 days later, she's overwhelmed by guilt and she confesses to the police. While it may stop the payout, I believe that she has committed the crime here. Some might argue that she's abandoned, but I don't think so because it's done. Maybe she didn't get the money yet from the insurance company. It's not in my example. If she fully gets the $1,000, is that the completed? That could be. That could certainly be argued that way. So, again, make sure when you're deciding whether there's going to be an attempt or abandonment, you always have to look through the facts. It's not always clear cut. It's not clear cut in the real world either. Definitely not clear cut in the real world. Attempt and transferred intent. Defendant's intent can be transferred from one intended victim to the actual victim. I thought, we talked about transferred intent. I want to shoot you. I'm a terrible aim. I miss, and it hits someone standing behind you. And I'm charged with what? There's you and your friend, and I shoot a gun intending to hit you, and I miss, and I hit your friend who's standing behind you. And we know under the theory of transferred intent, and I kill your friend, that I could be charged with murder for killing your friend because my intent of shooting you transfers to your friend. But can I be charged with attempt because you were my intended victim? Do I have I met the attempt steps? Do I have specific intent? Sure. And what was I going to try and do? I was trying to shoot you. So I could be charged with your attempted murder and the fact that that intent transfers to your friend for both. So attempt crimes, however, have a lower grade. And when I mean grade, I may have mentioned this, or I think we did talk about it early on. Classifications in New York, our felonies are listed as classes. Those are grades. Low, E, D, C, B, and A. A is our highest of crimes. E is the lowest. And attempt crimes are lower. There's a lower grade, hence they have a lesser penalty. And I think that is the takeaway of not completing the crime fully, right? If you complete the crime fully, then you're charged and could be convicted to the full extent and the penalties that apply and subjected to the penalties that apply. But when you have an attempt, it's a lower or lesser offense. Now, to give it some face with an example, better understanding, in New York, if you are charged with assault in the second degree, and that's the intent to cause serious physical injury to somebody, it's a mandatory prison sentence. I think it's maximum of 5 years off the top of my head. But if I don't get all the way through with serious physical injury and I'm charged with attempt, then what happens is if I'm convicted of attempted assault second, it decreases down to the next level, and it would be the lesser of the penalty under that. So if I tell you assault in the second degree is a Class D felony in New York, it will be a Class E. If it's attempted, it goes down one grade, and then the penalty for a Class E felony would apply to attempt. So hopefully that is clear. We have just finished attempt. It's a very big, important topic. The next two inchoate crimes we'll talk about are conspiracy and solicitation.